But let's move on to universal jurisdiction, which is a much talked about development in international law. And what this means is that a country has jurisdiction to try the perpetrators of a serious crime, even where these crimes have been committed abroad, and irrespective of the nationality of either the perpetrator or the victims for that matter. To put it in less legalistic language, a UK court could, according to this principle, try a Sri Lankan for crimes committed in Sri Lanka against Sri Lankans. So that is the principle of universal jurisdiction that is accepted for international crimes such as genocide, war crimes, crimes against humanity, and torture. And it has become to play quite an important role in seeking to hold perpetrators accountable where there are no other domestic avenues or where the International Criminal Court or such bodies do not have jurisdiction. But the problem in practice is that there are a number of requirements for the effective exercise of universal jurisdiction. And I just want to run through the key obstacles faced when trying to use this remedy, before then briefly discussing how that applied in the Karuna case that most of you will be familiar with. And the key and main challenge is that the country in question, and I will focus here largely on the UK more by way of example, will have to have jurisdiction. In a number of countries, the legislation is such that the courts will only be able to look into certain crimes, not all of the crimes. And in the UK, for example, international crimes are only subject to universal jurisdiction after 2001, and only for British residents, or will have temporal limitations. That means that they can only be prosecuted after a certain point in time, such as for acts of torture after 1988, and that also applied in the well-known Pinochet case. So the legislation is not always straightforward and does not necessarily allow all crimes to be prosecuted. This wouldn't be such a problem in relation to the more recent crimes we have been talking about today. But even then, the British legislation has a resident requirement. And that brings me to the next point, that any alleged perpetrator would have to be present in the UK. So that makes it, or even be a resident, so that makes it technically quite difficult to, say, prosecute someone, a Sri Lankan national who is just passing through. It's different where a Sri Lankan national is a resident or even a UK national. Then the third challenge is the one of immunity. Under international law, acting heads of states, acting foreign ministers and diplomats all enjoy immunity. So that means that those arguably bearing the greatest responsibility are actually shielded from such jurisdiction. Then there is also a practical challenge of obtaining and securing the evidence needed for a conviction in time. And this has come to constitute a big problem in practice. What we have experienced is that there are a number of activists around the world. There are reports by reputed human rights organizations covering all sorts of human rights violations, but when it comes to actual cases, all this information will not necessarily be sufficient to secure a conviction, because you need to corroborate that, you need to support this information with eyewitness accounts and other pieces of evidence. And in the case of Sri Lanka, that has proved to be very, very difficult, because there is such a pervasive fear amongst the victims and witnesses to testify, and this became very evident in the Karuna case. And a further obstacle is the institutional setup. You need to have you need to have investigative units and a prosecutorial policy in the country concerned, such as the UK, that is really capable of undertaking these investigations. And don't forget, the Metropolitan Police, for this matter, they're not able to go to Sri Lanka, and the unit responsible is also under-resourced, we understand. So there are also some institutional problems that limit the effectiveness of universal jurisdiction. So this has been quite technical, but I now want to illustrate how that played out in the Karuna case. Karuna was a military commander with LTD in the 90s, and later after his breakaway with the so-called Karuna faction in 2004, and in both instances he was implicated in having committed serious crimes. And so it was rather fortuitous from an accountability point of view that he actually came to the UK and was on a, I think, false diplomatic passport, and was actually arrested on immigration charges in early 2008. And he was in detention for several months, and there were then concerted efforts to have the British authorities prosecute him for the crimes committed. But what happened in actual practice, that, as I mentioned before, it was very, very difficult to obtain the necessary evidence because of the climate of fear and the pressure on the witnesses, but also because of some institutional weaknesses in the UK setup. So this is a rather sobering lesson, but I think for any future cases it will be important to be well prepared and to do your homework, if you like. And I will talk about strategies in a moment. Just want to highlight that there's also something called civil universal jurisdiction, which means that you may be able to sue individual perpetrators for damages in the UK courts. You can't sue the state because the state benefits from state immunity under international law, which is currently challenged both in the European Court of Human Rights and here in the UK House of Commons. But when it comes to going back to the criminal side, seeking to having individuals prosecuted, some government official who happens to travel to the UK, I think here it would be very important to get the strategy right and to compile a dossier with relevant evidence which would be strong enough to prompt the authorities to take the required action, to have all of this ready in time, to liaise with the authorities, to have a good network in place internationally with other countries and other organizations who can share information. So this would take a very concerted effort, and in a number of other incidents concerning other countries, be it, I mean, there are many, but Israel and the US have been very prominent. One of the problems in the so-called universal jurisdiction movement has been that activists, victims and lawyers have tried to target very high-profile perpetrators. And that has more often than not almost descended into political stunts, because they didn't stand a chance of succeeding. The people like Sharon that were targeted, they benefited, or Bush for that matter at some point, they benefited from immunity. So it was clear that there was no prospect of having a successful outcome. So recently